You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. This morning, before we commence our oral argument schedule, we have a special event. We have a new marshal at the Florida Supreme Court who called the court to order this morning, and we are going to give him a formal ceremony administering the oath of office. We are very pleased to have the new marshal here. His name is Sylvester Dawson, and he has had a distinguished career of public service before coming to the Florida Supreme Court. He joined the Florida Highway Patrol as a trooper many years ago, and moved up the ranks in the Florida Highway Patrol and became the Deputy Director and Chief of Staff of the Florida Highway Patrol. He was the Academy Director of the Florida Highway Patrol Training Academy, and he served in many other capacities of significant responsibility in the Florida Highway Patrol. Marshal Dawson also served our country in the United States Army, and we are very pleased that he has decided to become the Marshal of our court, and we are looking forward to many years working with him as this court's Marshal. Today we're pleased that we are joined for this swearing-in ceremony by some members of the Marshal's family. His wife, Susan Dawson, is with us. We're also pleased that Susan is an attorney in the Office of the State Court Administrator. The Marshal's son, Patrick Dawson, is with us. We're very pleased that you're here, Patrick. And the Marshal's sister, Sylvia Dawson, joins us as well today. We're very grateful that you could join us for this special occasion. I will now proceed to administer the oath of office to our new Marshal. We will now proceed to the first case on our docket, Hoskins versus the State of Florida. Counsel may proceed.
May it please the court. Good morning, Your Honor. My name is Rahila Meade, and I, along with my co-counsel, Ms. Carol Rodriguez, are here on behalf of the appellant, Mr. Johnny Hoskins. Mr. Hoskins sits on death row today, having been convicted on March 21st, 1992, of the murder of Ms. Dorothy Berger, and later being sentenced on November 12th, in 2004, to death. The procedural history of this case consists of 3 penalty phases. The first 2 penalty phases were conducted by trial counsel Randall Moore, who was Mr. Hoskins' attorney. The third penalty phase, which arose from a vacation of the death sentence and a remand, conducted by trial counsel Ernest Chang on behalf of Mr. Hoskins. And that is the sentencing That is the penalty phase that is at issue before this court today. We're here on an appeal of the post-conviction court's order denying Mr. Hoskins' motion to vacate his judgment sentence pursuant to Florida Rule of Criminal Procedure 3.851. Specifically, trial counsel Ernest Chang had an obligation to his client.
We know that. This is not a case where, because as you mentioned, there's two other penalty phases where there were other witnesses that Mr. Chang failed to discover, correct? That's not the focus for you is that they made a bad choice in putting Dr. Kropp back on, as well as two other experts, and they should have not put Dr. Kropp on and found another expert. So focus on exactly what you're saying was constitutionally deficient performance from Mr. Chang.
First and foremost, Your Honor, trial counsel Chang failed to put on any evidence, that was available to him of Mr. Hoskins' drug and alcohol abuse.
And I have a very hard time with that claim because, again, as you was in the first two penalty phases, was there any indication that he was, at the time of this crime, which really would be the critical point in which to try to mitigate this horrendous crime, not only just the rape, but what followed? Is there any testimony in the first two penalty phases that Mr. Hoskins was under the influence of drugs or alcohol at the time of the crime and in the 6 to 8 hours after when he murdered Mr. Berger?
Sir, Your Honor, there was nothing presented at the penalty phases as to Mr. Hoskins' drug and alcohol abuse. However,
well, let me just go back. So what we would be saying that all the prior counsel, you mentioned Mr. Moore, he was also deficient, that everybody that handled this case until post-conviction were, they were deficient in not discovering that he was actually under the influence of drugs at the time of this crime?
that is correct, Judge.
And where now does this evidence come from that Mr. Hoskins was?
I would submit to the court that during the post-conviction proceedings, first of all, we have, with respect to trial counsel Chang, he had the benefit of the pre-sentencing investigation report that showed in 1988 Mr. Hoskins had been convicted of a dangerous drug offense.
What was that drug offense?
That was how it was classified in the
I
pre-sentencing
thought it was,
investigation.
wasn't that marijuana, something to do with marijuana?
The pre-sentencing report only talked about him being convicted of a dangerous drug offense, Your Honor.
In which year?
1988 in the
4 years before this crime?
1988, Your Honor.
And when was the crime?
It was 1992.
4 years
yes,
before
Your
the
Honor.
crime.
Apologize. And furthermore, Judge, trial counsel Moore testified at the post-conviction hearing on page 373 that he recalled Mr. Hoskins telling him about a cocaine addiction at the time of the homicide. And also, Judge, if you look at in volume 10, which consists of the evidence of the exhibits in the post-conviction proceedings, you have Dr. Kropp's interview notes.
But do we have anyone, I guess the real question is, do we have anyone who actually testified that at or about the time of this murder, that they observed Mr. Hoskins taking drugs, that he was not in control of himself, of any of that kind of evidence in this record?
No, Your Honor, we have Mr. Hoskins' self-reports of his drug use around the time of the crime. Going back to Dr. Kropp's interview notes, on September 23rd, 1994, there was a visit between Dr. Kropp and two of the attorneys. At the time was Attorney Moore and Attorney Roden. And they met at the Brevard County Jail where they interviewed Mr. Hoskins about what had happened. And at the time, Mr. Hoskins reported to them that he had had blackouts and had sleep issues, and he'd been using cocaine about an hour and a half prior to the incident.
And so did he have a blackout about this particular incident?
There is some testimony that, and it comes from Dr. Eisenstein, and also from Dr. Kropp, that he had some memory issues as to what happened in this incident.
But at other times he seemed to have pretty clear remembrance of what went on during that time.
Judge, Mr. Hoskins' memory, I submit to you, has not been clear and has not been accurate, and that pertains to what Dr. Eisenstein testified about, that Mr. Hoskins does suffer from an Axis I mental illness.
Yeah, I think the problem that you have in this case, and the trial judge appears to have heard the post-conviction, appears to really focus on it. No one seems to dispute that it's possible, maybe even probable, that the sexual battery occurred as a result of some mental illness, some frontal lobe impairment, some explosive thing in a response to a perceived racist remark. The problem in the case is what he did after the sexual battery in terms of murdering Ms. Berger, which was binding her, gagging her, putting her in a trunk, driving for several hours, opening up the trunk, seeing she was still alive. All of that, and that went on for hours and hours with no evidence that he was on a cocaine binge or on some frontal lobe impairment episode for all those hours. So even if the jury may have found that sexual battery was formed in an impaired state, either mentally or but it's the hours that resulted in the eventual murder that the judge found that he made a conscious decision to avoid arrest in those actions. So how do you get around both, and that's true both for the drug and alcohol issue as well as for Dr. Eisenstein, how do you get around that very powerful factual scenario?
Certainly, Your Honor, the factual scenario is very powerful. However, I'd submit to the court that if trial counsel Chang had done something more, had spoken to his expert, talked to his expert about these impulse situations, you would come to a situation where Dr. Eisenstein can testify and explain how such a crime.
But explain to me how, because I'm not getting it, and you got to, part of it is to try to then not just give well, this is what the expert now says, but how would the jury, how would the judge respond to how would you defend the issue of what happened for the hours afterwards that was still under this influence? I don't see it. And jurors certainly have common sense, as do we, in terms of whether it's logical.
Correct, Your Honor, and considering the frontal lobe impairment, considering all his history of these episodes, Dr. Eisenstein did the best he could to explain that, and to explain that to a sentencing jury, how such a crime could occur. That the way that intermittent explosive disorder occurs, his actions after the sexual battery are still in accordance and still manifest of that disease, where he's still under that impulse, that irrational thinking, where he makes the wrong reason.
So did any of the medical experts explain that even though he may have had drugs at some point during that day, that he had a condition such that even though he wasn't still taking, let's assume he was not still taking any drugs during the whole time of the, after the rape and before the murder, that his condition was such that the effects of having taken the drugs earlier would still manifest itself during that whole time period? Did anyone say that?
Dr. Morton talks about it at the post-conviction proceedings. He talks about how Mr. Hoskins' prevalent drug history would affect him sort of in his physiology and would cause his reward centers to consistently want drugs, and it would affect his rational thinking, it would affect his behavior.
Did he ever say that it was such that he could not have formed the intent to kill Ms. Berger?
No, Dr. Morton did not testify to that extent.
And did he ever say that it was such that he could not have controlled his actions that led to killing Ms. Berger?
Dr. Morton talks about his behavioral responses because of the substance abuse and the drug abuse.
But was it ever said that he could have, that there was no control, that he had no control at that time when he was committing that murder? That the drug use would have put him in such a state that he had no control?
Dr. Morton said that he talks about him being impulsive and irrational, and that I would submit to the court, it goes to that issue of control, that his behavior, he didn't have control. He wasn't thinking like a rational man. He didn't have control of his actions, his behavior once the racial slur, if in terms of what Mr. Hoskins had self-reported, had instigated that, that moment that caused the impulse, the aggressive impulse response. And so that's where he lost that control, and that drug abuse and the drug history adds to it, along with...
Well, how do we deal with that drug history? It seems to me, I recall at some point in this record that Dr. Kropp had indicated that there was no major mental illness, that Mr. Hoskins had no major mental illness, and there was no real evidence of sustained substance abuse. So how do we deal with that in relationship to now you're saying that there is this evidence?
And Judge, that was in a letter to Attorney Moore back on October 21st, 1993. Yet if you look at the attachments, which were all of Dr. Kropp's interview notes, he makes several mentions of drug cocaine use, particularly cocaine use during and around the time of the crime. And that was in the attachment on 9/23/1994, where I was talking about him being at the jail with the attorneys. He talks about Mr. Hoskins reporting that an hour and a half he had taken cocaine. He had snorted cocaine in the car prior to a basketball game. He had snorted cocaine again at his home prior to going over to Miss Berger's home.
So, all right, let's assume that we accept that there is some alcohol and drug abuse in this picture. How does it change the aggravating and mitigating circumstances in this case? Because that's what we're really getting to, is whether or not the mitigating circumstances would have changed such that life would have been a more appropriate sentence, correct?
Your Honor.
So how do we get to that?
Your Honor, drug and alcohol abuse is a very weighty non-statutory mitigator, and along with the mental illness axis 1 of intermittent explosive disorder, which is also a very weighty statutory mitigator. A sentencing jury, in terms of looking at the statutory mitigators through the intermittent explosive disorder, the brain impairment, and also the comorbid diagnosis of the drug and alcohol abuse, a sentencing jury, there's a reasonable possibility that the sentencing jury would reweigh it and tip the scales in terms of life, especially because it explains how such a horrific crime could have happened.
Well, the problem you still have is that you've called this, or Dr. Eisenstein mentions IED, intermittent explosive disorder, but when asked how he got to it, he says it's because of the crime itself and then an incident related to a friend in which he became angry and began choking her, didn't release her until someone hit him in the head. So now you have more prior bad acts. Then he talks about an argument with a girlfriend. The judge, in looking at that, I mean, gave you the benefit of the doubt, but it doesn't really appear to be a very scientific or medical diagnosis. It's sort of saying, well, this thing happened. Sort of like, how could someone do this crime? And we always ask that, how do people horrible crimes? Not what a normal person would do, but have nobody on death row if that was the criteria. The issue is whether it would really outweigh the aggravator. And I see you're in your rebuttal, but if you just want, so I'm even questioning the diagnosis of this IED.
Judge, the intermittent explosive disorder is a valid diagnosis. It exists in the Diagnostic Statistic Manual for Mental Disorders.
No, I'm not saying it doesn't exist. I'm saying how it was diagnosed in this case. It's because he was violent in this situation and choked a girlfriend, therefore that's what he has, whereas his whole his school record shows him being a pretty compliant student.
Dr. Eisenstein, in terms of coming to this diagnosis, he has to find several discrete episodes. He found them, as the court referred to Teresa Kovac, he found them in the Department of Corrections disciplinary records out of Georgia and also Florida, with respect to the fights with the inmates.
I realize he
and
did, but the judge who was evaluating wasn't very impressed. And again, I don't want to, you are in your rebuttal, so either save the rest of your time.
Yes, Your Honor, if I may. Thank you.
May it please the court, I'm Ken Nunnally. I represent the state. This case is ultimately about second-guessing trial counsel. But let me go back to intermittent explosive disorder, Justice Perriente, and y'all are going to hear a case tomorrow with the same expert making the same diagnosis. The testimony at the evidentiary hearing was that intermittent explosive disorder is a very rare diagnosis. Not to make myself an expert, but this is the first case I've ever seen it in. First time I've heard of it. There are 3 criteria under the Diagnostic and Statistical Manual in order to make a diagnosis of intermittent explosive disorder. That's kind of a mouthful, so let's call it IED from now on. There have to be several discrete episodes of failure to resist aggressive impulses that result in serious assaultive acts or destruction of property. Now, this man has been on death row at the time of the evidentiary hearing for 15 years. He has gone the last 4 years on death row without a single disciplinary write-up. The second criteria.
It would be pretty hard, I mean, in death row to be assaulting. Well, can you go back to how old was he at the time of this crime?
He was up in his 20s, maybe even 30. I'm not entirely sure. He wasn't really young by any means.
But are you telling me, again, that the diagnosis of this disorder hinges on the actual prior incidences of violence?
Yes, ma'am.
So that the jury would, the more the jury would hear,
Exactly.
which would, of course, say...
And undercuts the mitigator that was found of no future dangerousness. It was found in the 3rd penalty phase. It wasn't found in the 2nd, and I'll go ahead and mention that right now. There were 9 non-statutory mitigators found in the 2nd penalty phase, which is the first one y'all considered, and that was the one that was ultimately reversed, or rather set aside, and led to the 3rd penalty phase. The 3rd penalty phase resulted in a finding of 16 non-statutory mitigators plus the age mitigator. Now, with that said, the second criteria for intermittent explosive disorder, and there are 3 of them, the degree of aggressiveness expressed during the episodes is grossly out of proportion to any precipitating psychosocial stressors. No real evidence of that, but again, that ties back into prior bad acts of violence that would undercut the kind of good guy, if you will, mitigation theory that defense counsel seemed to have. And the third one.
So, wait a minute, before you move from that, are you saying that there was some provocation for the explosive episodes that took place?
No, I'm not. We don't know enough about the prior episodes to really arrive at that determination. We're kind of going on the defendant's self-report. What we do know is that over 15 years at the time of the hearing on death row, there had been no write-ups for anything for the 4 years preceding the hearing, and there were really no write-ups for assaultive behavior or anything violent on death row, nor is there anything in his school records or really anything else to support the notion the guy had been violent in the past. It's just not there.
But isn't the real, I mean, and I tend to agree with you on this, but even if the episode of the sexual battery was caused by, whether you call it, I mean, to me, it's more impressive if it comes from an organic brain frontal lobe thing, which is what Dr. Kropp talked about. It doesn't explain, does it? It's a friendly question. Several hours after what he did.
No, even if you assume, and, you know, page 18 of my brief, it's kind of, you know, I don't want to go into it here, but even assuming the sexual assault was an impulsive act, that still doesn't explain the continuing behavior that went on for 6-7 hours
Let me
after
ask you,
that.
before you leave the intermittent explosive disorder, was any other experts ever asked about that kind of diagnosis, and was it ever affirmed by any other expert?
It was directly controverted by the state's expert, who testified that, first of all, this diagnosis is extremely rare, exceedingly rare, I believe was the phrase he used, and that the evidence of it in this was just not there with regard to Mr. Hoskins. Now, the third criteria for making an IED diagnosis is the one where we really get to trading off a lot of things that were going on, that the drug use, because the third criteria is that the aggressive episodes are not better accounted for by another mental disorder, and it lists some antisocial personality disorder, borderline personality, a couple of others, and are not due to the direct physiological effects of a substance, e.g. drug abuse. So, if you want to go down the road, or if defense counsel wants to go down the road of arguing intermittent explosive disorder, he's got to give up the drug abuse, because he can't argue those two together. And I would suggest that even if one assumes the sexual assault was an impulsive act, and the fact of the matter is, Hoskins told the state's expert that it was a consensual thing, page 18 of my brief, Justice Periente. It just doesn't work. You're arguing that impulsive or intermittent explosive disorder is a mitigator, is saying to the jury, don't kill my client because he is a really violent person who just can't control himself. And I would suggest that when you put that up against the mitigation that was found, that Mr. Chang put on and convinced the trial court to find in his sentencing order, that even if one can find some deficiency in his performance, which I do not concede is there simply is no prejudice.
I want to discuss something that does concern me. It has to do with Dr. Kropp. You know, when there's these repeat penalty phases and you have a new defense lawyer, there's always this question, well, how much more do you do? Mr. Chang said, well, he decided he'd do everything that was done in the first two penalty phases, more, put on 2 more experts. And that sounds good. But my concern is with Dr. Kropp is that Mr. Chang didn't know until the morning of trial that Dr. Kropp had met with Hoskins in 2003. Correct? He didn't know that till the morning or the night before trial?
That was the testimony.
Now, I'm not concerned with the additional testing. What I want you to explain to me is when there was a 2003 interview, what additional details did Hoskins tell Dr. Kropp about what happened between him and the victim after he opened the trunk?
Hoskins apparently provided more detail about that component of the offense to Dr. Kropp.
Well, what
But
you tell me I'm asking you what those additional details were, because my sense is, and I didn't go back and compare, is that some of the really horrendous stuff about this HAC comes out of what Mr. Hoskins tells Dr. Kropp in the 2003 interview. Now, if that's not, so you need to tell me what if you can, what additional details he gave in 2003 and how that differs from 1998. The judge sort of says, yeah, you should tell clients they shouldn't be confessing to their mental health experts, and sort of says you shouldn't have done that. but then says there were just a few more details, and I'm trying to understand that.
The bottom line to it, it's kind of a convoluted answer, and I can't get it all into one little compact area.
How is the question which asks, what additional detail was given in 2003? That's the first question. What was the additional detail?
Because the answer is he had already given those details in 1998.
Oh, that's what
He
I asked,
provided
additional.
some, I think, a little bit more description of it at the 2003 interview, but it was whatever he said, and I don't remember the specifics of it because it was wasn't really clear what new came out. But it was known in 1998 about essentially what Hoskins had said, because there's a letter in there from Randy Moore, to Randy Moore from Randy Moore, must have been to Randy Moore because Randy doesn't write letters, talking about it as well. But the bottom line to it, we're in a penalty phase. Guilt is no longer at issue and has not been for a very, very long time. And as Mr. Chang put it, he had to go with Dr. Kropp because Dr. Kropp is the one who was giving him the frontal lobe damage based on the PET scan. He has Dr. Wu and Dr. Wood giving him the PET scan. And all of this, whatever Hoskins said to Dr. Kropp was completely corroborated by the medical examiner.
I guess the way I was looking at it is that if you don't know until the day of trial that your expert had a complete additional examination in 2003 where additional details were supplied, and to me, the aggravator in this case that is the most horrendous aggravator is Miss Berger died. Now you're saying, well, the medical examiner says so, but you hear it from the defendant's own words. It's very powerful. I'm not saying, it may not still make any difference in the finding of HAC. I was just trying to ferret it out. I don't see how a good defense lawyer is preparing for trial doesn't meet with his main expert other than the day of trial and find out that there's a 2003 examination. That's just basic trial preparation.
Well, let me tell you
You
what.
can't tell, I can't see how that's not a deficiency.
It would have been better had he done it in advance. I'll give him that, certainly.
Are we really
But
saying we expect lawyers to put on witnesses and talk to them the day of trial, and that we expect that as being acceptable performance?
that wasn't the first time he talked to Dr. Kropp. It's the first time I think he met with Dr. Kropp face to face, but it wasn't the first time he spoke with Dr. Kropp. They had spoken on the telephone a number of times.
Dr. Kropp just happened to not mention that there had been a whole other examination in 2003?
Not sure what it looks like. It came, when it came, and if you go, you got to go back to the penalty phase itself, because when the 2003 examination started coming out, or when it started becoming apparent in Dr. Kropp's testimony that there was this 2003 interview, if you will, state objects to it because they didn't know about it either. There's a recess taken. Dr. Kropp is basically interviewed informally by the prosecutors to find out about this examination.
And that's when Chang's finding out about it.
Well, I think he found out about it a little before that. But anyway, but the bottom line is Mr. Chang had the chance right then to not use that evaluation and made the decision to go ahead forward with it anyway, because what he was getting from Dr. Kropp, he believed was better than what he was giving
He had
up.
no choice at that point. It's almost like one of those Richardson violations. Once he gave, hadn't he already given his opening statement? I mean, his whole case was based, as you said, on Dr. Kropp. And I'm just saying you would want to evaluate what those additional details were, and if they were sufficiently harmful, he now has the PET scan that shows abnormality, can develop another expert. So I think the whole strategy issue gets, doesn't really make a lot of sense when you find something out the morning that your expert's about to testify.
He could have kept the 2003 evaluation out and chose to go forward with it anyway.
Yeah, and that's what but I'm talking about the details. I don't really, again, the testing I don't think adds or subtracts. I'm talking about the details of what he was told.
He could have kept those out also. but he chose to go forward with using testimony about the 2003 evaluation. The state wasn't going to be able to go into it if he didn't go forward with it to begin with. And again, you have a this was the agreement that they kind of had worked out, that if he's going to go forward with it, the state's going to cross-examine on it. If he doesn't go forward with it, the state will not. He felt like he made the decision to use Dr. Kropp and go forward with Dr. Kropp's testimony.
Well, let me ask you about that 2003. I thought that in 2003 that Dr. Kropp had done some additional testing, and this additional testing really sort of affirmed his original diagnosis of this defendant and indicated that the defendant was not malingering and information like that. Was that the basis of this 2003 information?
I believe that's correct. I mean, the 2003 testimony, or for whenever it was, the last penalty phase testimony from Dr. Kropp focused largely on the PET scan and focused on his finding of frontal lobe impairment and this and that. That was all developed. That came in. It was found. The issue really, between the second and the third penalty phases became whether Dr. Kropp's testimony, quote, changed, close quote, and that's, water under the bridge. But the bottom line is that nothing that has been presented about this defendant, even in the most recent proceedings, undercuts the aggravators or adds mitigation. The best we can say, I would suggest, is that at most, and I'm not really saying this is what's accurate, but the most we can say is going on is that the label of intermittent explosive disorder has been applied to some of the defendant's behavior. But if you apply that label, and I'm again not saying it's really correct, you undercut mitigation that was found. So we're left with what I believe the 11th Circuit described as a what might have been presentation. I would suggest it's second guessing is what it is, because we have had 3 penalty phases. The first one was set aside by the trial court for reasons I have never known. The second one this court set aside. The third one this court affirmed on direct appeal. And now we're going to give a label to the defendant that is inconsistent with the evidence and is controverted by the state witnesses and suggest that trial counsel was ineffective. And that is not what Strickland is about.
Do you feel like you answered my the one question about what additional details was given in 2003?
They were minimal.
They were minimal?
They were minimal details. There was not a whole lot of doubt about what happened and about how the victim died in this case.
So he had already in 1998 given the whole detail of finger in the trunk and what happened. Is that?
I don't know that all of the details have been given. Details have come in spottily throughout the case. When you get to the most recent version, now Mr. Hoskins told the state's expert that he lied to Dr. Kropp about all that. So I don't know what the truth is. I don't know what he's going to say the next if he gets interviewed again. I have no idea what this man's going to say. But the fact of the matter is, the medical examiner's testimony was absolutely consistent with the victim having been alive in that trunk from Melbourne, Florida to Araby, Georgia, with a stop off at the defendant's house to pick up a shovel and a drive out to a peanut field where he strangled her.
Well, there's no question that we know when the gag and the binding took place. That had to take place before the trunk, so she's got to be alive at that point.
Yes, ma'am. And the medical examiner's testimony was that she was alive at the time she was killed in Georgia, because you have impact wounds consistent with those having been administered by a shovel, in addition to strangulation, which I believe was the ultimate cause of death. With all of that, you have got quite simply a horrific case, And you have got a nightmare case from a defense standpoint because you just don't have a whole lot you can do with it. Remember, this guy's MMPI was normal. You don't have mental state or mental issues here. This man's MMPI had one scale that was slightly elevated, and that, the testimony was consistent with someone who's on death row. So you have a defendant who, for whatever reason, committed this offense. You have a defendant who has changed his story. You have a defendant who ultimately strangled an 80-year-old lady after he kept her in the trunk of her own car after a stop-off to make repairs to the vehicle in Melbourne and a stop-off to pick up a shovel to use to bury her. And then when he returns and somebody sees, one of his brother, I believe it was, sees blood on his vehicle, says, "Oh, I hit a possum." I would suggest that this case cries out for the death penalty. And I would suggest that there is no error whatsoever in the trial court's denial of post-conviction relief. I ask the court to affirm.
In response to Mr. Nunley's statements regarding, first, that Dr. McLaren did not do any independent tests as to an admitted explosive disorder, he testified that he disagreed with Dr. Eisenstein's finding, and he testified in his experience it was rare. However, even Dr. McLaren recognized that based on the MMPI test that he did, which also Dr. Eisenstein did, that Mr. Hoskins, first of all, was validly testing. He was not malingering. And also he recognized that based on Mr. Hoskins' self-report, that he himself, Dr. McLaren, would put forth a diagnosis of cocaine and alcohol addiction dependency, and also based on the MMPI, he'd find that he had frontal brain impairment due to self-administered intoxicants. Even Dr. McLaren found that he would diagnose him with a personality disorder. Even Dr. McLaren recognized that there was mental illness and drug addiction and alcohol addiction evidence present in his own testimony, which corroborated along with what Dr.
It still would never, I don't see how it ever mitigates this crime. I'm still back to that, which is, it doesn't, if it had ended at the sexual battery with that she died as a result of the wounds from the sexual battery, maybe some jurors might buy that, but not the incident, the binding, the gagging, the taking in the trunk, the opening it up, the hitting with the shovel, the manual strangulation. It's just, it's too much. I mean, and you're doing a good job on it, but for your client, but he's got to live with and receive the consequences of what he did that day.
I certainly understand where Your Honor is coming from. However, when Dr. Eisenstein talked about statutory mitigation, he talked about the episode where Mr. Hoskins had impulse control loss with respect to the rape, and he talked again what happened at the time when he opens up the trunk, and in 2003, the additional evidence being that now Ms. Berger was alive at the time, that came out, well, that trial counsel Chang found out the morning of the penalty phase from Dr. Kroc. That was another episode where she said something, and he once again had an impulse control issue, and Dr. Eisenstein talks about that. And that goes back to the statutory mitigator.
So what are you saying were the additional details in 2003? That she actually said something when he opened the trunk?
Mr. Hoskins talked about when he opened the trunk in 2003 that Ms. Berger was alive, and that was a new memory that he had at the time, and that she said something, and that's when he snapped and he grabbed her by the neck. I believe was what Mr. Hoskins had told.
Did he explain how she did that with the mouth gag?
I'd submit to the court, I believe that she did, Mr. Hoskins said that she had done something because it caused that impulse control.
Didn't she kick at him to try to save her life?
She did kick at him, yes, Your Honor. And, Your Honor, Mr. Nunley stated that because we have drug abuse, we don't have intermittent explosive disorder. As I said before, Dr. Eisenstein explained you can have both so long as it's not the main reason for the aggressive disorders, and he did find it was an Axis 1 mental illness with a comorbid diagnosis of the drug abuse. And I'd ask the court, in looking at the frontal lobe impairment, the mental illness, intermittent explosive disorder, and the drug and substance abuse that was prevalent, to find that those are statutory with mitigators, and to spare Mr. Hoskins' life and remand this case for a new sentencing.
Thank you. We thank both sides for your argument. We'll now proceed to the second case on our docket, which is in re amendments to the Florida Family Law Rules of Procedure.
May it please the court. My name is Stephen Colmes. I'm chair of the Family Law Rules of Procedure. I am here on the 3-year cycle report. There are 2 issues presented by this 3-year cycle report. One involves a change to constructive service in cases involving children, and the other involves the establishment of a collaborative law rule. Beginning first with the jurisdictional, with the attainment of jurisdiction by constructive service and issues regarding child custody.
Could you first tell us, in a situation where someone, a father or, is out of state, and the petitioner is declared indigent, but and I think the most admirable part of the rules change is really requiring specificity in the affidavit, and you kind of, in your
Yes.
comments, say, if knock
nothing
off the
else,
other thing,
leave that in,
and
please.
I think that's very important, that people really know where the spouse or the father is, and they just don't tell. But if they know where they are they required to actually, personal service, to personally serve them out of state?
Under the UCCJEA 61.509, the specific language of that statute is notice must be given in a manner reasonably calculated to give actual notice. So if you know where they are, you have to give them notice, again, consistent with the laws of the other state, that would actually provide notice. Some states that allow certified letters as a service of process, you might be able to send them a letter.
Well, in this constructive service, first of all, you analogize it to the situation where you're trying to find the legal father.
Yes.
But there, the legislature has provided for the method of constructive service. My concern is not only the issue of the financial burden that is being raised by legal services, but is whether this is really a legislative determination about how service is made, not a procedural. That's number one. And two, the effectiveness, let's just assume that what they can do then on constructive, they don't know where the person is, and they are going to post it at the courthouse in the last known address, and we think that's going to and cause them to, again, do something that the legislature hasn't required, something that is unlikely to cause anyone to have actual notice, and three, that at expense. So it doesn't seem that if your goal is to enhance the way parents are notified, that this provision that's the only thing that's controversial is really something that we ought to be delving into. And so let me hear your honest response about that.
The honest response is there's a bit of a quagmire here. What we are trying to do is, reasonable notice and the opportunity to be heard are the cornerstone of procedural due process. And that's really what we're trying to get to the bottom of. And I agree with most of what you said.
This is what I love. I love your idea that the committee hopes the court might suggest that the legislature consider whether it's time to begin utilizing the internet in some manner to provide more meaningful notice. And my suggestion is, rather than the court suggesting that, why doesn't the family law section, lobby the legislature to make some meaningful changes so we have more up-to-date notice than requiring somebody to pay money to post it in a courthouse in another state that most likely will never accomplish what you want to accomplish?
Several things said there I'll try to respond to. First of all, with regard to posting in the courthouse and internet as an alternative to that antiquated type of service where people actually used to go to the courthouse to conduct their business. We are the Family Law Rules Committee. We certainly have ties to the family law section, albeit informal ties. And if there were not a rule that required, if there were not a rule that would resolve this issue with regard to the UCC-JEA attainment of jurisdiction by constructive process, then that is certainly something that would probably occur in due process of events. But I would just add that the legislature has spoken somewhat on the use of constructive process in these cases in 61.509 in the adoption of the UCC-JEA, which says, which provides that constructive service may be used. The problem is it's in a vacuum. What does that really mean? And that's part of what we were trying to remedy. And I think when we received the comments from Bay Area Legal Aid, we realized we had taken a very conservative approach to the dual publication. We weren't happy about that. I used to serve as a magistrate, and I know the people that come before the court with these type of cases. And having them published in one newspaper is going to be difficult enough, especially in these economic times. A second newspaper may keep people from being able to cross the threshold of the courthouse doors.
Right, and I mean, especially because it's not going to, I mean, because the thing we really want to do is encouraging them to actually find the person.
Yes.
And actually notify them. I mean, and to me, that's what the court ought to be, and is, and that's what this rule, why I think the new form and the affidavit and what they have to put in there is, I commend the Rules Committee for that. I think that is the most, I mean, again, you agree, that's the most significant advance, because what we really are aiming for is actual notice.
Yes.
I'm a little confused. Is the court, where the court located, where the service is to be provided, is that the court where this proceeding is going on, probably where the minor child is, or is it in the locale of the defendant somewhere in another state?
The location under Section 49, under Chapter 49?
Constructive service, because where it says in the county in which the court is located.
Yes, that is the county in which the family law proceeding is pending.
Not the county and the defendant out of state somewhere, right?
No. But if you know that somebody resided in Columbia, South Carolina, what the rule would envision is that you would publish in the county where say it's an Alachua County case. You would publish both in Alachua County where the case is pending, even though there may be no connection whatsoever with the absent parent, but Chapter 49 requires that. But then under the UCC...
49 requires that now?
Yes.
That you publish in the place, if you know they're in Columbia, South Carolina,
yes,
you would publish there?
Yes.
Okay, so...
That's the problem. And that is a problem that was resolved, I think, with the adoption.
Why is that a problem now?
Because if you know the person has lived in Columbia, South Carolina all their life, and you don't know where they are specifically, but you believe that they're probably there, you're not required to actually constructively publish in that locality. You're just required to constructively publish in the county where the court is, even though the person may have never stepped
I
into
don't think, well, I didn't understand you to say that the first time. I thought you said that it's now required that you publish both places.
Currently, it isn't. The rule is that you would.
Okay.
It is not.
The amended rule.
Okay.
Okay.
But I thought that's what you said.
And that would be whether you're an indigent or not. I mean,
yes,
that's what the comment really is about, is how this rule, as it's being proposed, would affect someone who is an indigent.
Absolutely. That's what Bay Area Legal Aid's primary concern is, indigency.
And so even if we would accept this proposed rule, an indigent person would have to publish both in, say it's pending here in Leon County, would have to publish here, and if they believe that the person lived in Seattle, Washington, they would have to publish in Seattle.
Yes. And one thing that Bay Area Legal Aid points out is that they could post in Leon County, in the Leon County Courthouse. You actually take a piece of paper and you put it on the wall, the notice of action.
Instead
But
of
wouldn't that
Instead of
defeat-
publishing, when you're indigent, you could do that.
But wouldn't that defeat calculated to actually notify somebody of the?
Antiquated service of process is how we refer to it in our reply.
I mean,
So could they post also in Seattle, Washington?
We do not know. I do not know the answer to
That's what
that.
they're saying, that they don't know it could cost them money to post someplace else. But you're still conceding that this posting in a courthouse is no longer going to be calculated to give somebody, you don't know where they are, notice of something that's very important. We're talking about their child.
Well-
And we're not talking about, a sum of money, which we're talking about the outcome of this child, I guess. And this is why, to me, this is a legislative decision, because what I'd rather, if they're going to require indigents to spend any money, let them, take the effort to go and Google, like, the person's whereabouts. You can just about find anybody these days if you try, right? Or not?
We discussed that in the committee, that we have all Googled ourselves at one time or another, and that if notice was somehow provided via the internet, that might be the easiest way to provide somebody
do
notice.
courts have their own websites? Do each court have their own website?
Do each courts have their own website?
Yeah.
I do not know the answer to that. I do know that there are many courts where there's e-filing already, where you could do a search and a case may come up, especially with PACER, for instance.
Well, if the ones that do, I know some do they have notices like that posted on their website or no?
I'm not aware either way.
That's
Not that I
interesting,
know
whether
of.
posting now is broad enough to allow posting on an internet site, which obviously would be better and not cost anything.
Agreed?
Has there been any kind of studies, though, to determine whether folks that find themselves in these circumstances even have access to internet?
I believe, one, I don't know the answer to that, Your Honor.
That's, I
but-
mean, and we're assuming that everybody in every household and all across the world has internet access. I don't believe that's the case.
They
I'd
probably
like to see
have-
some statistics, but
They might have better access to the internet than they do to the Leon County Courthouse lobby.
Well, isn't the idea?
is that the way
of
we
posting-
write our rules on what might be? I mean, I'm missing something here. We're talking about there's a problem for the indigent, and why would we not approach this, that maybe there should be some exceptions or something, but the basic notion is to give people notice, isn't it?
Yes, Your Honor.
That's the basic fundamental, and if we need
Yes.
to carve out exceptions, why not do it that way rather than approach it to throw out everything and give no notice because some may have a problem?
I believe that currently the statutory scheme in the state of Florida provides that posting is just for indigents.
Isn't the notion of having a notice where this courthouse is and the proceeding is a father who has known of the likelihood or possibility of having fathered a child and has an interest in that child would perhaps circle back and try to find what happened? Is that the reason for the notice posted we're in this location?
The reason for the notice is of legislative origin. It's to acquire in rem jurisdiction over the issues in the case. We're talking about constructive notice. It doesn't create any in personam notice. Generally, with regard to property, it's not going to be an issue as long as in the notice of action you specify the property.
And again, for the legal father thing, the legislature has spoken.
Yes.
And they've required it. I think, and again, isn't this then, if it's not required now by the legislature, isn't it an additional requirement that the legislature is not imposed? I'm not understanding why that's not a substantive change versus a procedural change.
The legislature says that it needs to be a method that is reasonably calculated to give actual notice. That's the legislator, that's the legislation. It must give actual notice. All we're trying to do is say that if you are going to serve constructively, make it as good as it can be. And as good as it can be is
How
not
could
to publish it in
posting-
Leon County.
Well, posting in any courthouse is not as good as it could be. So we're deficient then, because I agree with Justice I mean, to me, the issue of a certified letter at the last known address, it might come back. I mean, there must be other ways that don't cost money that would actually give notice to somebody unless they don't want to be found at all, rather than the posting thing.
We don't necessarily disagree, other than that's the current statutory scheme for providing constructive service is publication in a newspaper of general circulation or posting in the courthouse. That's statutory. We have no control over that. We're trying to deal within the statutory scheme. We agree with everything you guys have said. Your honors have said, excuse me. We agree with everything that you've said. We've had the same discussions in the committee, and it is a quagmire, and it may very well be that it is a problem for the legislature to address, and it may be beyond the Rules Committee, and it may be beyond the court to impose a resolution.
If we pass this rule, if we approve this rule, tell me exactly what would happen if a person has no idea where the father is.
All right.
What would they do?
Okay. Well, first of all, everybody should have a last known address. Part of the problem is people are coming in front of magistrates and judges, and where it says last known address, they go unknown. Well, you knew the person at one time, you made a child with them, except in the most extraordinary circumstances.
Let's assume the last known address was right here where this proceeding is taking place, but you now have no idea where this person has gone.
Well, then, are we to assume the person's also indigent?
Let's go with indigent also.
Then you would post in the courthouse lobby.
That's it.
That's it, in that one place. Where it becomes more complicated is where the last known address is out of state. Because
and then
we
if
don't
the last
know,
known address is out of state, let's have the same scenario, but the last known address is out of state.
And now I cannot answer your question because I'm not familiar with the other 49 statutory schemes for constructive notice.
The other state has the same kind of constructive notice provisions that we have.
Then one would attempt, if they're indigent, to probably contact the clerk of the court and see if there's a possibility of posting in the lobby.
And so you would you post in the lobby where the case is pending and the post in the lobby where the last known address is?
Yes.
But if you had the last known address, wouldn't we require them to first send some letter to see, actually, rather than go to posting, wouldn't we want to try to still get with actual notice?
The proposed amendment to Rule 12.070 would require the clerk to mail to that last known address the notice of action.
And
so that is also covered automatically within the rule.
It's requiring people to be honest with the court about where the person is likely to be.
Yes, Your Honor.
All right, we thank you.
All right, thank you, Your Honor.
Good morning. May it please the court. My name is Dick Motley. I'm the managing attorney of the Newport Ritchie office at Bay Area Legal Services. Among my other duties in that job, I'm a journeyman family law attorney representing a client population that's indigent, as that term is defined in Chapter 57.
Is the chair of the Rules Committee had suggested that if the party seeking the relief is indigent, that the extent of what that indigent party must do is a posting. Is that your understanding?
Well, prior to that, there's the diligent search. Diligent search and inquiry is required publication or posting either way. If you're going to use constructive service,
all right.
Statute requires diligent search and inquiry.
And it's posting.
Correct.
I'm missing something
and
here.
And if a last known address is known, the clerk mails to the last known address, even currently.
I'm missing what the aggravation is with the legal services for indigents if that is the only thing that's required.
The statutory scheme as it exists right now would only allow posting in the county of filing. It specifically, I think, states that. The second county, they want to do it, require the publication also in the county of last known address, last known residence. If that is other than the county of filing, there is no statutory authority to post in that county. I would not be able to access the posting statute to do that. Therefore, I would be prohibited from completing service under the new rule.
So it's not correct then that indigents can satisfy everything by merely posting, is what you're saying?
Not under the proposed
under the
rule.
proposal.
Correct. That's my problem.
Well, but again, you must understand that there's a broader world than just the indigency world. I mean, there are folks that may move to a jurisdiction just to avoid giving notification to a spouse. And that we do need to have something that protects those interests while recognizing interests of those who cannot afford it. So I have a problem with trying to make, why is it not better to carve out an exception for your concerns than to just throw the whole concept of trying to provide actual notice out the window. Let's phrase it that way.
Right. I guess needs to be clearly understood. I'm not here against notice. I'm here pro-access to courts is really what I'm looking for. I'm looking for the petitioners
But
in
not
these
for
cases
all.
to go
But not
forward.
for all. The other
Right.
spouse doesn't have the same access as the party filing. So let's go to my question, and that is, why is it not better to carve out an exception for a class, if that's what the real concern is, and permit the other people to try to receive actual notice as best possible?
Actually, in preparing for today, I became aware of the case law on this issue. This court has addressed this issue before. In 1974, this court issued a decision called Grissom versus Dade County, and that was, I think, a follow-up to the United States Supreme Court in Bodie versus Connecticut, which was 1971. In Grissom versus Dade County, individual wanting to do an adoption, this court expanded the Bodie case to include adoptions. Ms. Grissom was indigent. At the time, the posting statute did not exist. Only publication existed for constructive service. This court found that to be unconstitutional and directed service of the publication to be paid by the state. Some of my position, if you do away with my ability to post, I think this then falls back to that case, which I'm not sure that's an acceptable solution to the court at this point.
What happens when, let's go, you said something important, which is this first has to be diligent search. And I'm assuming, and again, this is an important issue of the absent parent and just the question of whether shenanigans are occurring.
Correct.
Someone's trying to get, and again, I'm trying to, this wouldn't be for support because we're talking about in rem. We'd be talking about just parenting plan. And obviously, if the person's absent, they could, unless they don't know the child exists. So on the one where the legislature has spoken that the legal father, you need to do constructive service in the place of their last known address, how do you deal with that now? Because there's no, is there an exception for indigency?
Actually, that appears in two places. One is the adoption statute and one is the child support. The child support statute, I think, runs solely to the Department of Revenue. It's in Chapter 409. So I think it's not really an individual cause of action statute. The adoption statute, it's not an area I practice in, so I don't know what people who have that problem do in the case to solve the problem.
But there's, but again, so the issue is the legislature has spoken there to require it. Now, in the cases where you said you do the affidavit or you do your diligent search and you find that the person 2 months ago lived in Atlanta, Georgia.
Yes.
Okay. Now, what do you have to, what does the statute require you to do as far as actual notice?
I think if you follow through the statutory scheme, it still is a constructive service case. There's case law also that you can use personal service also. I would generally use personal service at that point.
So how do you pay for that?
Good question. It was a question there. We would often, you either have to, many states will do it pro bono. If you send in the affidavit of insolvency, other states you have to pay.
Well, do you think, though, and I want to go back to whether, first of all, if it's substantive, I think we have a problem. And is your argument that the legislature, that we're encroaching on what the legislature is doing, or you're not making that argument?
My argument really is that we can't, there's no legislation approving or allowing that posting in the second county at this point.
But isn't it consistent with the legislature's intent?
There's no really, the legislature doesn't express an intent. It just says you can post in the county of filing. So, but yes, I think there's no reason to think the legislature wouldn't approve of that.
Could you tell me in the real life of indigents, and I'm talking, I'm mentioning internet, and we're talking now posting, I don't know, does any county in this state, does the clerk allow posting on their internet site?
No, I think by statute it has to be at the courthouse.
So is that ever a way, do we know in real life if people, is this antiquated, this whole scheme?
I don't think in real life absent parents are perusing the internet to see whether anyone's bringing a parenting time case.
Or are they going out in the courthouse?
No.
So I guess the issue really is if it's going to cost more money and a problem, and it's not going to really do anything, because what you said is the clerk now sends it to the last known address anyway.
That's my understanding. Yes, that's by statute, yes. Thank you very much.
May it please the court, I'm Robert J. Merlin. I'm a board-certified marital and family law attorney with the Florida Bar. Practice family law, especially collaborative family law, through my office in Coral Gables, Florida.
So you don't have to worry about these indigents, huh?
This is, well, I do a chunk of pro bono work, but that particular issue is not why I'm here before you this morning. I'm appearing individually as the president of the Collaborative Family Law Institute, which is a group of collaborative professionals in Miami. We have over 80 members.
Let me ask you this about that. Quite frankly, I did not know we had this kind of procedure. So when did all of that get started?
In 1990, a gentleman by the name of Stu Webb from Minnesota realized that there has to be a better way of handling divorces than going into the courts.
But it's not something that you go through the courts to do.
The whole purpose of the collaborative process is to stay out of the courts, to empower the parties to resolve their own issues. And the only court involvement in a typical case is that once the agreement is signed, it will be submitted to the court for the entry of a final judgment.
So why do we need this whole rule structure? Maybe that's, in other words, it occurs outside the court. There's now legislation even referring, no legislation.
No, we have,
why do we
have proposed legislation that hasn't gotten through the legislature yet.
Well, why do we need this whole long rule about something that occurs outside the court?
It's a very good question. So what happens, just to give you some background, the parties and the specially trained attorneys enter into a contract, which is called a participation agreement. That agreement sets forth the terms of their collaborative relationship. This is going to be a voluntary process. It's going to be transparent. We are going to voluntarily exchange all information, no depositions, no interrogatories, no court hearings compelling discovery.
And you represent both parties?
No. Each party has their own attorney. When necessary, we use neutral experts. We use mental health professionals to help the parties get through the process. The most important aspect of the collaborative process is that the parties agree in this participation agreement that if either party wants to leave the process, which they can do at any time they want to, those collaborative attorneys will not represent them in litigation.
So you never file a notice of appearance in court?
Well, that's not exactly true, because it is possible to have a pending action, stay it, and then go into the collaborative process.
And have the judges not been doing that?
Well, that's also an interesting question. In Dade County, in Brevard County, and I think in Orange County, there is an administrative order, and the administrative order is set forth what the judges are supposed to do. Yes, they follow that. The problem is that from a public's perspective, there is nothing stopping anybody from holding themselves out as a collaborative attorney and not following this procedure. There's in the rest of the state, other than those 3 circuits, there is no procedure for what to do with this situation where they've gone to the collaborative process, they have a signed agreement, and then it breaks down, and what's to stop the attorney from coming in and just continuing to represent the parties?
So this is another form of mediation.
It's
but
not
it's
mediation.
Outside of the court process.
It is an alternative dispute resolution process. Its philosophy is the same as mediation, which is to help the parties resolve without having to go into court. This is a process that will enable the parties to control their own destiny. Mediation is focused on the negotiation of a settlement. The collaborative process is everything from identifying issues, gathering documents, negotiating.
So if that process works, what do? You then file your divorce action and along with your complaint, file this agreement that you've already come to, and in essence, you have an uncontested sort of divorce?
Not in essence, in actuality, that's exactly what you have. And so we're saving a huge amount of money in the judicial system.
But still tell me why then we need this rule. Why do we need, if this is the way it's working and it sounds like it's a great process, why do we need to step in and have a judicial rule about it?
Because the public needs to be protected, because those professionals who are practicing it now are doing this voluntarily, but there is nothing requiring someone to do this.
So we're going to protect the public from attorneys who are being unscrupulous?
I'm not saying any attorneys are being unscrupulous, but there's nothing stopping an attorney from saying, I'm collaborative, I'm just going to say I'm collaborative, but not really be.
This is what I want to understand, because I know that there are, the people, and I'm all for alternative dispute resolution,
Yes.
and it's, when it works, it's wonderful and empowering people. But as you said, the legislature, I thought they had passed. You've tried to get things passed there. I know there have been issues about it. Is the court, by adopting this rule, recognizing something that we, from out of ignorance, we don't have the same detail? Are we doing something more than just a procedure, or is there some other reason, and please be honest, that you want the court to be recognizing collaborative law process, and maybe if no one objects, we should just do it. But could you explain if there's anything else other than we should be putting in a rule what's in the administrative order of 3 circuits?
Well, certainly establishing the standards and having a standard throughout the state is the ultimate goal. Honestly, I personally would really love for the Supreme Court to establish a rule, because I think that is going to promote the process throughout the state. Attorneys are going to say, what is this rule? The public is going to say, what is this collaborative law process?
And they'll ask the justices, and we'll go, we don't know.
No, they're not going to ask the justices. They're going to come to their local attorneys and say, do you practice collaborative law? Or they're going to come
So
into
okay, so you're being on, you are using this in a way to promote this practice.
Right. If the court does not approve this rule, the collaborative process and movement will continue. But at some point in time, there are going to be people out there. In fact, there are people now who advertise themselves on the internet saying that they're collaborative. They have never been trained. They don't even know what it is.
Why isn't the Florida Bar looking to regulate this? I mean, why shouldn't we have the Florida Bar putting forth what the ethical standards are for someone who holds themselves out as a collaborative lawyer? That seems to be what you're really aiming at.
This is a rule of procedure as stated in the sections, the Rule Committee's brief. That is an alternative to do this through the rules of professional conduct. This is the status of the case. This is how it's been presented as a rule. We're all in favor of the rule. We want to get some standards in the state to ensure that the public can rely upon people who hold themselves out as being collaborative as meeting certain standards.
Well, you're talking about different standards for lawyers who are involved in this process other than somebody who just would be doing the case? I mean, are you trying to get a qualification for somebody like a mediator?
I would love to see that happen, but that's not what this rule does. This rule basically says you must have a participation agreement. That participation agreement must state certain things in it, and you have to follow this procedure.
Any practicing lawyer who's representing a client could do this?
Absolutely.
All right. Now, if this were done, could a court order mediation or no?
Well, yes, the court could order mediation, but the process would be that they're not in court at that time. They're out of the judicial system. But for instance, if the collaborative process breaks down and they go back into court, sure, the judge has the power to say, go to mediation. And in fact, in the collaborative process, if the parties and attorneys are not able to negotiate a resolution, we bring in a mediator and try and mediate it ourselves. Thank you very much for your time.
Thank you. Thank the other counsel. The court will now take a 10-minute recess.
All rise. Supreme Court is now in session. Please be seated.
We now go to the third case on today's docket, in re amendments to the Florida Rules of Judicial Administration.
Good morning, Your Honors. May it please the Court. I'm Kathy Giddings, and I'm here in my capacity as Chair of the Rules of Judicial Administration Committee, and you have before you the 3-year cycle petition in which there are a number of rule amendments proposals, and I'm actually, since we have no one on the other side, which is the first time I've ever been here without someone on the other side.
You better not lose this one.
Yeah, well, since I am here to serve you, I don't consider what occurs a loss or a win. So it's a win-win situation because we view our service on the committees as a service to this court.
I do have a question about one of the rules, and that is Rule 2.530.
Yes, ma'am.
That's the one about the communication equipment taking depositions by telephone?
Yes, Your Honor.
And I thought there was some concern by someone about whether or not you should allow the taking of the depositions by telephone even over the objection of one of the parties.
There was one comment filed as to that rule, and it was actually in support of the rule. What it actually wanted was expanding the rule that we were proposing to not only include circuit and county judges, but to also include magistrates and hearing officers. And they also wanted us to
but should we allow the taking of these depositions if one of the parties has some valid objection to doing it by telephone?
Well, Your Honor, right now, this proposal has been up before this court. This specific rule has been up here. I have 3 cases in which this court has addressed this rule.
And we've rejected it every time.
You've rejected it every time, and the reason, the rule itself, what we're proposing is actually consistent with what this court has asked for. What has happened in the past is that the committees, depending on the type of substantive law that is at issue, they're on diametrically opposite ends of the spectrum. The criminal rules and juvenile detention, they do not want, unless all the parties agree, they do not want telephone testimony or out-of-court communication testimony. But the Civil Rules Committee is very much in favor of over the objection. And what we did was we polled all of the committees, and we got a diverse response. And so what this court has said in its earlier opinions, when they tried to expand the rule to be to allow a judge to allow this over the objection of a party, was the court wanted it tailored to the specific type of substantive area of law that was at issue. And so the reason this came, basically, that was never able to occur. No one could ever agree on a proposed rule. So this came to us again because there are 2 glitches in the rules. In small claims, there is a rule that allows the judge to have testimony over the objection of the parties. And that's, it's small claims court, it's a much different type of court. There's also a provision in the civil rules that gives the judge some discretion to allow this in a deposition standpoint, and then it can be used as testimony at the trial. And so since the committees could not agree on an across-the-board rule proposal, we came up with this proposal, which actually says that instead of just allowing it if all the parties consent, we're saying that if all the parties consent or if permitted by another applicable rule of procedure.
But why do we, I guess, if it's permitted by the other rule of procedure, where's the glitch?
It's a conflict because you've got a rule of judicial administration that says that they can only do it if it's by consent.
So all we're adding is or if permitted by another rule?
Exactly. And then that would allow the Civil Rules Committee or the Criminal Rules Committee, if they wanted particular rules, then they could come up with a rule that's designed for them. And that would address this court's concern that it has said over and over again in the 3 cases where it's addressed this rule before.
So they could come up with a rule that says that it can be done even if one party objects.
Right, but it would be, just like in small claims, it would be specific to that particular practice area. For instance, in criminal, you have a lot of due process concerns, and in the opinion that Justice Lewis wrote on the juvenile detention rule, he was concerned that it had become a matter of routine and that they were not bringing children into court and they were taking away the discretion. So that was one of the reasons why they didn't want in juvenile detention proceedings to have that rule there. But in small claims, traffic, or in civil, you have different concerns. You don't have necessarily the confrontation due process types of issues. So we felt like this would address the glitch, and we didn't take really a position. The family law section wanted it expanded to include all judicial officers, but that term's not really defined. What they're wanting is hearing officers and magistrates. So those are usually, I believe, used in family law type proceedings. So it might be that family law would have a rule of its own in that regard, since judicial officer is not defined. But they address that in their comments to this court.
Well, but would that do it? Because if this rule, as a rule of judicial administration, is going to govern other rules,
yes,
correct?
Sir. Yes, sir.
So if it here says a county or circuit court judge may allow testimony, wouldn't that in effect limit the ability of the other rules to allow somebody other than a county or circuit judge to allow the testimony to be taken through communications equipment?
Your Honor, that's a very good point. I mean, we did not get to study their proposal because they made that recommendation and then we had to file an immediate response. And so that did when this rule came to us, we weren't looking at who had authority to do that. So we said, listen, we do not have an objection to the rule being broadened, but there's no definition for judicial officer.
So just include, if we just add hearing officers and magistrates, would that solve it?
Perhaps. I don't know any other of the different categories. I mean, Well,
we know. I mean, there's hearing officers and there's magistrates.
And there's special well, I guess a special master would be a magistrate, or we don't have those.
I mean, we may, but I'm saying in terms of what's recognized in the court system, there's hearing officers and magistrates.
Right, and as an appellate lawyer, I rarely am down in the trial court proceedings where we have the special proceedings, and so I'm not necessarily familiar with all of the different terms. But we, as a committee, we do not have an objection to broadening it if this court believes the policy should be to broaden it.
The small question, no controversy about including the telephone number of a litigant in a motion to withdraw. And that's so that the court has a way, because we right now require the address, but to be in touch. Right. Since we're starting to get slowly into electronic age, if the litigant has an email address, might it not be a good idea to add, either a phone number or an email address if they have one?
It's funny that you asked that question, because when I was preparing for oral argument today, I thought of that exact same question, and I believe that when it came through, that it was at the specific request of a judge to include a telephone number, and we're going to be talking tomorrow about the e-service rule, and I believe that the pro se's that they don't want to require it as a matter of routine, because unlike attorneys, they don't always have.
Well, I know that, but this must be a way that the judge is trying to get in touch with actual notice.
Yes.
And so they're asking you to put the phone number in. I'm just saying, if as we get down, so we don't keep on doing this incrementally, if the person is, if it's a sophisticated individual, why not, if they have one, add that too?
I don't think that would be a problem. I don't foresee any problem with that, other than the fact it just needs to be if they have one, whereas attorneys are required to have one. And I believe under the rule.
This is only, maybe the litigant doesn't have a phone number either. If they don't have one, they don't have one.
That's a very good point, Your Honor. That's a very good point. And I don't believe we would have any objection to requiring their email address. I know that in the e-service rule that we'll be talking about tomorrow, that they're requiring attorneys to give both a primary and a secondary address, so email address. The one thing that I would like, I think that the pro hoc vici rule is self-explanatory. There were a lot of problems. Apparently, people, when they were reading the rule, did not understand that they had to reapply at each level, the trial court and then the district court level and this court. So it's being clarified, and I think that's pretty self-explanatory. The one thing that I would like to emphasize is on the ADA compliance with the documents. I think that there is a significant amount of education that's going to need to occur. I think that the rule should be implemented now, and it's a very good rule, but I don't think that there is a lot of information out there for lawyers. I don't think that the knowledge is out there for what is an ADA compliant document. I mean, I do documents every day and had to really dig deep to figure out what I needed to do to make a document ADA compliant. And so one of the things that we've recommended as a committee is that there be a significant amount of education. Sort of like with recycled paper. You know, you enacted that rule, but because it was a policy and you wanted, years ago when that rule was adopted, there was a lot of discussion on enforceability and how do you make sure that there's recycled paper. This is going to be a gradual phase-in type of thing for lawyers, but it will give the clerks a rule to point to say when if someone is requesting making an ADA request for a document that's not ADA compliant, it gives the clerk a rule to point to tell the lawyers your document needs to be ADA compliant. It's actually not that difficult once you get into it. Just like with Word, what has to happen, as I understand it, is that the document for the blind has to be there are a number of software programs that read the document from text to speech or text to Braille, and there's certain things that they can't read, such as pictures and graphics and tables, charts. So what they do is they implement a little tag there, either in Word or a PDF document, that just says, this is a graphic showing Kathy Giddings' signature, or this is a picture of, so that the scanner knows, and you also have to do your tables in a particular manner. The other thing that apparently gives these readers a very difficult time is headings, because you or I can look at the table of contents in a brief and know to go to page 50, but with a blind person, the page numbers are going to be different because it's the speech, it's the text to speech. There may not be a page number, and so your headings, if you use the styles in Word, and there's the box that you check in ADA Adobe, then that allows when the software scans the document, it allows them to know, okay, this is a heading, so I know this heading is somewhere else in the document, and I can locate that easily. And so apparently, if you use the styles in Word, then it makes it ADA compliant. But I searched out there and couldn't find a lot of information. There is some on this court's website, but it doesn't give step-by-step instructions. And I think it would be very, very helpful if we had somewhere, either on this court's website or the bar's website, step-by-step instructions for how to make a document ADA compliant.
Does the federal law require all documents that are filed with a court to be in compliance with ADA, or just upon request?
It's actually not the documents that are filed with the court. It's because the court has the obligation under the statute. If you look at this, all arises from Section 282-603, and that is a statute that says each state agency shall develop, procure, maintain, and use accessible electronic information that conforms to the ADA. And when I first read this, I went, well, state agency, that's not a court. But after further investigation, that particular act defines state agency as including judicial court records. But it says you don't have to go out and buy specific software.
But we have all our paper documents. None of them are,
but this is only for documents that are e-filed.
But what I'm saying about it is, we have had to deal with this in the court, and it's not an easy, it's not easy, which I don't understand why it can't be easy, but I've been told it's not easy, that when you go to something that might be more accessible to more people, it may be costly. Have you found for an attorney what it would cost for them to convert a document?
I actually ask a lot of questions about that in preparing for today, because you can get $800 software, but there's also software out there that's very, very cheap. But I think part of the problem that you're running into in trying to make documents and that type of thing compliant is that the documents that you get, like the briefs that you get, are not already ADA compliant. And for instance, if you create a document and put it into Adobe, then it's fairly easy to put it into ADA compliance, because you had the initial document to put into a PDF file. But if you have a copy of a copy, then you can't make it ADA compliant.
Well, when we are going, to this e-filing, I know there is, when they goes through the portal, the clerk's portal, that they can convert something so that it is searchable. Why, instead of trying to impose this on every attorney in the state, why not require that as it comes in through the e-portal, that there be software there that converts something to ADA compliant for everything? So not
well, Your Honor, I don't know the feasibility of that. The reason that we adopted this rule was because we received a letter from the court asking us to adopt this rule.
Okay.
And so we did it because you guys.
I want to understand better
the court, okay.
We got a letter from the court, it's in the materials, asking us to adopt a rule that requires the documents to be ADA compliant. So that's why we went down this road.
I want to understand better exactly what the ADA requires. That is, do they require everything, all court records, to be ADA compliant, or just those upon request?
It's my understanding that everything is supposed to be compliant to the extent possible. That everything is supposed to be extent possible. Now, I spoke at length. Your staff here was extremely helpful. I've spoken to Debbie Howells, Pollock, and I believe Tricia Knox is also very involved in it. And so it's my understanding that the Department of Justice is actually looking at proposed rules right now to come in and look at websites and tell government agencies your particular site is not ADA compliant. So I think at some point in the very near future, they're going to be examining websites to see if they're compliant. And I was thinking about this morning. I went to the restroom, and you've got your water fountains, you've got them at different heights, you've got bigger doors. This is just the next phase in making sure that people can access things. Are we saying that we're going to adopt this rule and it is going to, all of a sudden, all these documents are going to be compliant? No. It's going to be a process over time, and so that's why the bar needs to get involved in education. They need to post these things, post
on the courthouse.
Well, and I did a search, and Maine has accessibility guide, Word documents, here's what you need to do. And I think there's some fear that if you post it and somebody does this and it's not considered ADA compliant, that have we given them wrong instructions? But at least this tells you something. Because before I started looking into this, I had no clue how to make my documents ADA accessible. And now I've got to go back and tell my staff that from now on out, we're going to use styles with our headings on our Word documents, and if we convert them to PDF or e-filing, we're going to make sure that we click the right boxes by the headings.
Seems like you'll be the perfect person to do a webinar for the rest of the bar.
I don't know about that, but I do think it's going to require a lot of education. So are there any other questions, Your Honors?
Well, are we currently out of compliance with federal law?
I believe that the law says that you have to be compliant to the extent that there's not an undue burden, and your staff has been working extremely hard at making everything ADA compliant. It's my understanding that all of your opinions when they're issued and your website, to the extent possible, is ADA compliant, and this is one more step in facilitating the goal of
In other words, it will make it easier for us to do our job if the attorneys help out, and
Right.
if they have knowledge and it's not an undue burden, it will help us make these accessible. But you're suggesting that we actually be more specific on our website,
Exactly.
and that the bar does its job.
And it's my understanding now that, Tom, what happens is right now, if someone makes a request for a document that has, like a brief that has been posted that's not ADA compliant, Tom Hall calls them and says, resubmit this to us in an ADA compliant form. But if you make that request, then that person's going, because it took me quite a while to figure all this out, and now that I know it, it seems fairly easy. But I talked to my own IT staff, and they thought that a PDF document, you had to have a PDF document to be ADA compliant. They didn't realize that you could do it in Word. So I think it's just, like I said, a matter of education. All right. Thank you, Your Honors. We appreciate the opportunity to be here today.
We thank you. We will now move to the fourth and final case on today's docket, in re amendments to the Florida Rules of Appellate Procedure.
Good morning, I'm John Crabtree. I represent the Appellate Court Rules Committee, and I'm in Kathy's same box. The first time in my career I don't have an opponent, so I'm a little bit at a loss.
As you see, you've got enough to deal with up here.
Apparently so. Do you know that we have some comments we received? We addressed all of them except for 3, or all of them to the satisfaction of the commenters. And 2 of those were from Harvey Reuven. He wanted us to give the clerk's office 50 days to submit the record after the transcripts were complete, and we wanted to keep it at 20 because there would have already been 50, and our thinking was that the clerk's office already had sufficient time to get its ducks in a row to finish it up once they received the transcripts, and this is a criminal appellate rule, and we particularly did not want there to be unnecessary delay. He also believed that notice that the transcript had not been provided and the record was not yet done should not be provided to parties, but only to the appellate court. And again, we did not agree with that. We thought that as a matter of due process, at least, that everyone should be notified. The other rule where we received a comment and we didn't agree was from a gentleman, I believe his name was Mike Rollo, who wanted us to expand new 9170 to include orders refusing to enforce settlement agreements. And we did not feel that that was in keeping with the spirit of either the old rule or the new rule, and so we rejected that suggestion as well. But beyond that, we have worked out things in the comments, and we have no opposition. So I guess I would welcome any questions from the court. Or wish you all a great morning.
Let me ask you a question about Rule 9.140, appeal proceedings in criminal cases. In the portion that has the subsection D, withdrawal of defense counsel after judgment and sentence or after appeal by state, and that's Appendix C-9. 10, actually, C-10 is where the language is there. And basically, if I understand this rule is, as it says in the comment there, it is amended to clarify the rule as it governs procedures before a defendant's trial attorney may withdraw from the case following conviction and sentence. The purpose of the amendment is to recognize the newly created Office of Criminal Conflict and Civil Regional Counsel and to clarify representation in those cases. So this is a rule that now addresses representation in just refers to publicly funded defense appeals, and it refers to the public defender.
It does.
And the amendment expands it to refer to the District Office of Criminal Conflict and Civil Regional Counsel.
It does.
Let me ask you, and this, I may be missing something very elementary here.
Okay.
What about circumstances where the defense is publicly funded, but counsel is registry counsel? That's where the public defender's conflicted out, and the regional counsel has conflicted out, and they've had to go to registry counsel.
Well, I'm not sure exactly how that would play out, to be candid. I know that in this rule, what we were largely trying to address was a concern about handoff from the trial court criminal defense lawyer to the appellate court criminal defense lawyer. And that was our primary impetus for this amendment.
Is there some reason that the handoff would be handled differently for publicly funded cases where there's registry counsel as opposed to publicly funded cases where there are these other two types of counsel?
Candidly, none that I can see, Chief Justice Kennedy, no. I mean, I do see the problem. I will tell you, though, that Jonathan Morrison from the Public Defender's Office came here to babysit me in case I got in trouble. And if he has anything he'd like to share on that,
Jonathan Morrison from the Public Defender's Office of Miami. We don't have a particular position on that rule. That does make some sense. The reason this...
Now, what makes some sense? That we would...
To also have a rule that addresses what we call wheel counsel, the privately...
appointed private counsel.
Appointed private counsel, I guess.
Don't you call the registry counsel real counsel?
Wheel counsel.
Oh, wheel. Oh, but no, he's talking about... we got registry... which is in capital cases. You're talking about...
No, I'm not talking about capital cases.
Oh, you're not?
No. I'm talking... But my understanding is they refer to these appointed counsel as registry counsel because there is a registry.
Okay.
There's also a registry for...
All right.
For
colloquially, it was a rotational system, and therefore it was the wheel, for lack of...
It's what happens when you can't hear too well.
And when perhaps counsel doesn't enunciate very clearly. It does make sense to deal with that. The reason this rule, I think, is written the way it is because there's a statute that very specifically deals with the public defenders for the 5 DCAs that have appellate counsel will take all of the appeals, not only from all of the public defenders within the district, but also all the regional counsel in the district. There is no statute that I know of that deals with what happens with the registry attorneys, we'll call them, with the privately.
They don't have to stay on the case until the record is transmitted also? I thought any attorney did.
I think they do, and I think that's probably why there's no statute, because the statute just deals with regional counsel and public defenders. All other private attorneys would be covered by, it would be a private attorney just like any other private attorney, and the same rule has to apply. They have to stay on the case until, even under this new, until the record is assembled. And the simple reason for that is just because we're sitting in Miami-Dade County. We get appeals out of Key West. It is very difficult for us to get a record assembled out of the Key West courts. Therefore, if the local attorney will take care of that and then pass the case to us, that's the point of all this.
So you're in the issue with whether they're private attorney paid or private attorney appointed. There's not an issue in those cases? Is that the
I don't think it is an issue, except as Chief Justice Kennedy pointed out, it says in publicly funded defense. And
well, wouldn't there be cases where
this might qualify for that?
Where you'd have privately appointed, publicly funded appointed counsel, private counsel at the trial level, where that might not be necessary at the appellate level?
Oh, that's often why. That's why the whole statute is written as it is, so that it funnels everything back to the public defender.
Well, so why wouldn't that be part of the same scheme?
It probably should be.
Because part of this is that they've got to let the trial court know about the appointment and kind of focus on the fact that I'm publicly funded counsel.
Yes, although the trial court should know that. The trial court should have been the one that did that. The trial court should have been the one that appointed them in the first place.
I'm sorry, I should have said the appellate court.
Oh.
Yeah.
Yes, point taken.
Although I really don't see that there would be any impediment to us adding them. Can you think of any reason why you would not add the privately
No, Your Honor, I
appointed,
cannot.
court funded?
No, Your Honor, I cannot is the simple answer to that.
Is there a best, how would we best refer to them? Can you?
I would use the statutory language. I think it is registry. It is definitely not what we would colloquially refer to them as. But I would just use the statutory language.
We have the expert, so now I think the answer to your question is we should probably put that in as well. There's no reason not to. Are there any other questions from the court on any of the other rule proposals? If there are not any, thank you very much for your time.
All right, we thank you, and we thank you as well. That being the last case on our docket, the court will now be adjourned.
All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.